Hi, I'm Bradley Bick and I'm from Workplace Health and Safety Queensland, and I'm here today to talk to you about the model health and safety laws. The process of harmonisation commenced in July 2008 when the Commonwealth, state and territory governments signed an intergovernmental agreement to agree to harmonise health and safety laws across Australia. That process resulted in a national review with over 232 recommendations submitted to Workplace Relations Ministerial Council members for approval. Following on from the review and the recommendations being endorsed by ministers, the National Model Work Health and Safety Act was drafted and sent out for public comment in late 2009. That act was endorsed by ministers in December 2009. Following on from that process has been the development of the model regulations and codes of practice. The IGA, or the Intergovernmental Agreement, basically requires each jurisdiction to implement the model legislation as mirror laws in their jurisdiction by the 1st of January 2012. Essentially, this means Section 16 of the Queensland Act should be the same as Section 16 of the Victorian Act or in New South Wales. All jurisdictions are on track to commence their laws by the 1st of January 2012 this year. In terms of the benefits of this process, really it is about greater clarity and simplicity for all parties because we will all be starting on the same page from the 1st of January this year. In terms of national businesses, they're the ones that are going to have the most benefit from this process. There'll be greater certainty and understanding of health and safety laws for them because they can comply with one set of consistent laws regardless of what state they're operating in. There will also be lower compliance costs because those national businesses, rather than having to develop systems and maintain systems to cover 8 different jurisdictions' legislation, they can spend that time to develop company-wide prevention programs based on one set of consistent laws. And that also flows through to economies of scale in terms of their training and deployment of health and safety expertise throughout their organisation. For workers, this really does result in consistent safety standards, and this means a worker working with asbestos in Victoria has the same standards of health and safety as a worker working with asbestos in Queensland, and that just makes sense. For government, there will be some reduced expenditure in terms of our policy function and in terms of developing health and safety laws into the future. And I should say, moving into the future, the Intergovernmental Agreement covers that any future changes to health and safety laws will have to be taken up through that national structure and agreed at that highest level before they're implemented in all the jurisdictions. In Queensland, we had our Work Health and Safety Act 2011 passed by our Parliament earlier this year, and that Act is scheduled to commence on the 1st of January 2012. That Act does 3 key things. It repeals the Workplace Health and Safety Act 1995. It also amends the Electrical Safety Act to ensure consistency with the Model Work Health and Safety Act. And by that I mean it ensures that the categories of offences matches that of the Model Act, and it also ensures external reviews are also taken by the same external review body as the Work Health and Safety Act. Finally, that Act repeals the Dangerous Goods Safety Management Act 2001. That Act does include the flammable and combustible licences issued by local governments. So from the 1st of January next year, flammable and combustible licences will no longer be issued. They'll be abolished in total. And it also means for employers that they can just go to one Act and look for all the requirements for hazardous substances and dangerous goods in Queensland. In terms of transition to the new scheme, Queensland Act does include a number of transitional principles, and they have been based on the model principles. They really ensure that there's a smooth transition from the 1995 Act through to the 2011 Act when that clock ticks over on the 1st of January 2012. The important key transitional principle is that there will be no grace period come the 1st of January next year. The reason for that is that the harmonisation process has been in train for a number of years, and there's been extensive media about that process. It also is because the duties in that new Act are really considered the express expectation of the Australian community. And finally, not to have a common start date would undermine our regulators' compliance and enforcement function, and also just undermine the intent of harmonisation altogether. When you look at the transitional principles, and I do recommend that you go onto our website and download the Plain English guide to our transitional principles. The transitional principles really cover everything from prosecution, so how we'll prosecute persons under the 1995 Act, and how we'll prosecute people under the 2011 Act, but more importantly, how we'll prosecute people for contraventions that occur over that changeover period. It also covers things such as the appointment of health and safety reps, and the important part about this principle is that there's no need for employers to rush out and hold elections on the 1st of January next year to reappoint their health and safety reps. If you're a rep under the 1995 Act, you'll continue to be a rep under the 2011 Act for the duration of your appointment when you're originally appointed under the 1995 Act. It also covers such things as notices issued by our inspectors, and that means come the 1st of January 2012, those notices will still remain in force and be enforceable, so there'll be no need for our inspectors to rush out and reissue all those notices, and any further contraventions will be dealt with under the compliance and enforcement powers in the 2011 Act. To assist people understand the new Act, it will be supported by a number of different documents. The explanatory memorandum, which is really a section-by-section description of all the provisions of that Act, and that's currently available from our website. There'll also be 4 interpretive guidelines covering reasonably practicable, who is a person conducting a business or undertaking, officers and due diligence, and discriminatory conduct, and those documents will be available in the next few months. There'll also be a wide range of fact sheets supporting the Act and also the model regulations. We also have a national compliance and enforcement policy, and while it's important we have consistent health and safety laws, it's also important they're supported by consistent compliance and enforcement. The National Compliance and Enforcement Policy really covers how we'll monitor compliance and enforcement with the 2011 Act. That document provides how we'll prioritise certain incidents that come to our knowledge, how determine what sort of things that we'll actually go out and visit, and it also covers what types of tools that we use to get enforcement, and that's everything from verbal instructions through to improvement and prohibition notices through to prosecution in the court system. I should also say that you can also look at our website in terms of the national compliance and enforcement programs and statewide programs that we have, and details of those are available on a regular basis. I guess the key message from this presentation is, for Queensland, it really is business as usual next year, and the reason for that is that the duties imposed on workers, persons conducting a business or undertaking, those upstream duty holders such as designers, manufacturers, suppliers, are all generally the same, so it really is business as usual next year. Just moving on and looking at some of the more specific duties in the legislation, looking at the primary duty of care for the person conducting the business or undertaking. You can be a person conducting a business or undertaking with the primary duty under Section 19, but you can also be a person conducting a business or undertaking with management or control of a workplace or workplace plant or fixtures. Vice versa, you can also be a person conducting a business or undertaking with those higher duties such as designers, manufacturers and suppliers. Coming down from that primary duty of care, there really are 7 elements that make up that primary duty of care. The first 5 are very consistent with what we have in our current Queensland Act, and they include providing a safe work environment, providing safe plant and structures, providing a safe system of work, looking for safe use, handling, storage of plant, structures and substances, and providing information, training, instruction and supervision to your workers. So they're nothing new for Queensland. The other 2 that are new elements of the primary duty of care include adequate facilities for the welfare of workers, and they really are the amenities, the toilets, the tea rooms, the lockers, the showers. Queensland has had those provisions covered in our regulation, but this links it up to that primary duty of care, and that's something that an employer has to do. The final one is monitoring the health of workers and monitoring the conditions of the workplace. Health under the new Model Act is not just physical health, but also includes psychological health. So it's an important thing to remember that monitoring the health is not just about that physical well-being that you can do through health surveillance for people using hazardous chemicals, but it's also about that psychological well-being in your workplace. The other part of that element is about monitoring the conditions of the workplace. And depending on the nature of your business, if you're a small business, you can monitor the conditions of your workplace through a simple walk-through inspection. But if you're a more sophisticated business or a large business, you might have a full health and safety management system, which might have third-party auditing, and that would be how you could monitor the conditions of your workplace through those elements. In terms of what's new for a person conducting a business or undertaking, it really is that primary duty being qualified by so far as reasonably practicable. And reasonably practicable is determined objectively. It means that a duty holder must meet the standard of behaviour expected of a reasonable person in those same circumstances. You can also break it down into two further elements. It's about what is possible in those circumstances, and whether it is, the second part is whether it's reasonable in those circumstances to do all that is possible. So basically it means what can be done should be done unless it's reasonable for that obligation or duty holder to do something less. In terms of the provision itself, it talks about the elements of reasonably practicable, things from the likelihood of the hazard or risk, the degree of harm or the consequences that might result from that hazard or risk occurring, the state of knowledge in relation to the hazard or risk and the ways of eliminating that risk, and also the availability and suitability of ways to eliminate or minimise that risk. Only after considering all those elements should the duty holder consider whether the cost is grossly disproportionate to controlling that risk. And I think the bottom line is, regardless of the risk, if there's a risk in your workplace, it needs to be controlled, and whether you decide to buy the luxury version of that control measure or whether you decide to buy something that's a lot more basic, it is about controlling that risk in your workplace. There are also new provisions regarding consultation for duty holders, and basically section 46 of the Act says that if you've got a duty, if more than one person has a duty for the same matter, that you must consult, cooperate and coordinate with that other duty holder. And this is a very important feature of the legislation. For example, on a construction site, every person conducting a business or undertaking would essentially be required to provide first aid for that workplace. But through this provision, through consultation, coordination and cooperation, one person can provide that first aid equipment for that whole site on agreement, and then it's just up to the other people conducting a business or undertaking to give their workers training and instruction about how they can access that first aid equipment. And this is a very important thing moving forward, particularly into the regulations. In terms of worker consultation, the worker consultation provisions are a lot more extensive, and you need to consult with your workforce about identifying and assessing hazards, determining ways to control those, and also about decisions on procedures in terms of procedures for issue resolution, procedures for consultation, and procedures for provision of information and training in your workplace. You can consult with your workforce through a variety of different ways. You can consult with them directly, which might be through emails, it might be through toolbox talks, or you can consult through some of those other structures such as health and safety reps or health and safety committees that might exist in your workplace. The legislation also covers the matter of issue resolution, and this really is a new area for Queensland. In terms of issue resolution, if you do have a dispute about a health and safety matter in your workplace, it is a requirement for your workplace to go through the issue resolution procedure. That procedure can be followed. The procedure itself is actually in the regulations, and you can choose to follow that procedure, or you can choose to write your own procedure which meets the requirement of the regulations. And I think that's a really important thing for your workplace moving forward next year. Give that some thought in terms of whether you would like to write your own or whether that you'll be following the regulation itself. The important thing to remember with issue resolution is that a party to that issue can bring another representative into that workplace to give them advice. So for an employer, it can mean you can bring in your advisor, you might choose to bring in your solicitor. For a worker, it might be bringing in someone from the union to give you advice on this matter. And the important thing to remember is that it doesn't necessarily have to be someone with health and safety expertise. It might be someone with strong negotiation skills that can help get this matter resolved. For employers, this is a very attractive way to do business because ultimately resolving issues at that workplace level means that there's no need for an inspector to come out and adjudicate on that matter. Obviously, if you get to the end of this process and you do have agreement, it needs to be in writing. If you can't get agreement, it is time to call in the regulator and get an inspector to come out and conciliate on that matter in your workplace. The next key provision I'd like to talk about is the duty of officer, which is section 27 of the Work Health and Safety Act 2011. First of all, I'd just like to talk about who is an officer, and the definition of officer is taken from the Corporations Act 2001. Really, an officer is that person at that high level in your organisation, and we're talking about directors, company secretaries, partners, office holders, and we're also talking about receivers, administrators and liquidators. Those people that are making decisions that affect the whole or a substantial part of the business. So it's that CEO, it's that CFO level. In contrast, the people such as health and safety managers or building maintenance managers, they're really the people that are implementing the decisions that are made by these officers. So there is a distinction there that a manager or a supervisor is not considered an officer in the context of this legislation. It's also at this point in the presentation I generally get asked who is considered to be an officer in the public sector. In terms of the public sector, again, it really is that high level. So we're talking about Directors General or Associate Directors General, and those are the people that are captured by that officer provision. The health and safety duty of an officer requires them to exercise due diligence to ensure compliance by the person conducting a business or undertaking or the company that they're looking after. Due diligence is broken up into 5 different elements under that section. Basically, it requires corporate officers to take reasonable steps to have an up-to-date knowledge of health and safety matters, to have an understanding of the nature of their operations and the hazards and risks associated with that operation, to ensure that the company has appropriate resources and processes in place to eliminate health and safety risks in that workplace, to also ensure that the business has appropriate systems in place to investigate incidences that happen at that workplace in a timely manner, and also to ensure that the business has processes in place to ensure compliance with health and safety laws. As we know, workplace health and safety officers will not be a feature post-January 2012, and the department is promoting businesses to retain their workplace health and safety officers as trained safety advisors in their businesses to assist corporate officers in exercising their due diligence requirements. In terms of the officer duty, Queensland has always had a duty on executive officers, but it has worked in a little bit of a different way, and by that I mean the provision under the current 1995 Act says that if the corporation commits an offence, that officer has automatically committed an offence. And then at that time, the officer has certain defences available to them in terms of that they weren't able to influence the decision making of that corporation at that point in time. This moves it to a proactive, positive duty. So officers need to be proactive and ensure they're exercising due diligence in their organisation and have these systems in place. Essentially, it means an inspector could ask to speak to your CEO or CFO and ask them to provide evidence of how they're complying with their due diligence requirements. And unless that officer is able to be forthcoming with evidence, an inspector essentially could write a notice requesting that officer correct that contravention. And just going back to my previous comments, that having a trained safety officer in your business can go a long way in demonstrating those due diligence requirements. In terms of workers are required to exercise reasonable care for their own health and safety and to ensure their acts or omission do not adversely affect the health and safety of others. This is fairly consistent with what we have in Queensland, except the test is different. So under the new legislation, we're talking about reasonable care, and again, that's an objective test, and it's a standard applied to a person who and their behaviour expected in those same circumstances. So for example, if we're looking at a plumber, we'd look at the standard of an averagely trained plumber. Under the current Queensland Act, the 1995 Act, it talks about the obligation of a worker is to not willfully or recklessly interfere with anything provided for health and safety, and to not willfully place their health and safety or the health and safety of others at risk. So there is a different test there. It's about willfulness, and that is a lot harder to prove under the current system. The reasonable care test moving forward is a lot more consistent with the other duties contained in the new Act. For workers, under the current Queensland legislation, the definition of a worker is someone who carries out work for the business other than under a contract of service. The new legislation moves to a different model where it provides an inclusive list of who is considered a worker under this legislation. And workers include employees, so those direct employees to your business, contractors or subcontractors, employees of contractors or subcontractors, labour hire company, workers, outworkers, apprentices and trainees, work experience students and volunteers. Arguably, it is the same effect because Section 28 of our current Act says you've got to ensure the health and safety of workers and others, and arguably others includes anyone else that can come to your business, including contractors or visitors or people on work experience. What does make a difference in this new scheme is the definition of worker impacts on your consultation arrangements. So previously I mentioned there's a duty for persons conducting a business or undertaking to consult with their workers about various different things. The definition of worker broadens who you need to consult with. So consulting with your workers is not just consulting with those direct employees, it's about consulting with subcontractors or contractors that might be on site. And it also means that those people can also form part of your consultation arrangements in your workplace. So essentially you could have a contractor that is a health and safety rep in your workplace. Other new features for workers. The new legislation allows workers the right to cease work if they are exposed to a serious risk. This is really nothing new for Queensland. There's always been the common law right for workers to cease work where there is a serious risk. The good news about putting this into black letter law means that there are some governance arrangements around it, and by that I mean it's not just about workers putting their hands up and saying this is too unsafe to work, I'm going home. The legislation provides for the process of what needs to happen if workers are ceasing work. And first of all, it's immediate notification to management and then going through that issue resolution process to try and resolve that matter. If the matter can't be resolved, obviously you can always call in the inspectorate and we will come out and look at that matter in accordance with our national compliance and enforcement policy. But it also means that workers, the legislation provides for workers to be deployed to other suitable duties at your workplace or other duties at another workplace. So it is not just about workers walking off the job, it's about trying to get resolution of that matter. The new legislation also provides that health and safety reps can direct workers to cease work, and reps will be able to exercise that power once they've undergone training in directing workers to cease work. Again, the same process applies, that the health and safety rep has to consult with management if possible before directing workers to cease work, but if not, immediately after that's occurred. The other features for workers is that it allows the formation of multiple work groups. So currently in the Queensland system, health and safety reps have an area of representation, and sometimes that can be the whole workplace or it might be parts of the workplace depending on whether there's more than one rep. The new model works on work groups in your organisation, so you could essentially have a work group for your day shift, your night shift, you might have one for the south wing of your business, the north wing of your business, or you might have one for your office-based workers, you might have one for your field-based workers, or you might have one for a certain group of occupation in your organisation. This allows for a lot more flexibility in terms of how your workers can be represented at that workplace level. And essentially the shortened story of the process is that workers will ask to have health and safety reps in your workplace, and the first point is to negotiate with your workforce what work groups are going to be formed in your work group. Once those work groups have been decided, then it's a matter of holding the elections and then appointing health and safety reps to those particular work groups. The good news is the legislation provides for even broader representation within a workplace by allowing reps to appoint deputy health and safety reps, which is something that we haven't done in Queensland before. And it also covers the training requirements for health and safety reps and for deputy health and safety reps. Those people will be entitled to a 5-day initial training course on request to their employer, and at that time the employer must facilitate that training within 3 months of the request and cover the reasonable costs of that training. Following on from that, reps will be entitled to a 1-day refresher course each year after that. In terms of penalties under the new legislation, we're moving to 3 categories of offences. The Category 1 offence is the most serious offence, and it's about recklessly exposing a person to the risk of death or serious injury or illness, and we're not expecting many prosecutions in this category. The offence carries a $3 million maximum penalty for a corporation and up to 5 years imprisonment for those officers of that corporation, and it really is about that intention and gross negligence in that Category 1 offence. The Category 2 offence is about exposing someone to a risk of harm without that recklessness element in that offence, and that carries a $1.5 million maximum penalty for a corporation. And then finally we've got the Category 3 offence, which is you have a health and safety duty and that you fail to comply with that duty, and that carries a penalty of $500,000 there. So the increase in penalties, the maximum current in Queensland is $1 million and the maximum penalty under the new legislation is $3 million. So it really shows the seriousness of these offences moving forward. In relation to penalties, the Category 1 offence is a crime because of the quantum of the penalties associated with that offence, and those hearings will be heard through the District Court, and the Category 2 and Category 3 offences will be heard through the Magistrate Court system. As part of the review recommendations agreed that there should be an avenue for appeals right up through to the High Court of Australia, and our legislation provides for those appeals to go through that process. Currently, under our current system, once a case gets to the Queensland Industrial Relations Court, there is no other avenue of appeal. There's also an independent right of review where the regulator doesn't prosecute for a Category 1 or a Category 2 offence, and that independent review in Queensland will be provided by the Director of Public Prosecutions. In terms of inspectors' powers, there's not a lot of new stuff there. Really, their powers of entry and their specific powers, once they've entered your workplace, are all very similar and consistent with what we currently have. They'll all still have improvement and prohibition notices, and they're very consistent with the current provisions. The only new thing is that a person that is given a notice must display that notice in a prominent place, somewhere close to where that work to which the notice relates to, and that notice needs to be displayed while it's in force. There is one new notice, which is a non-disturbance notice, and inspectors will issue that where it's necessary to preserve the site or prevent disturbance for an investigation. And this links up to a section in the Act which says that if there is an incident at your workplace, there is a duty for the person conducting a business or undertaking to preserve that site until an inspector arrives or releases that site. The other important feature of this new legislation is that it removes the right of silence. So under our current legislation, if an inspector asks a person to answer a question or produce a document or a record, that person can refuse to do that on the basis that it might intend to incriminate them. The new legislation removes that right to silence, so if an inspector does ask a question or asks for a certain document to be produced, that document has to be produced. But the legislation does go on to provide further protections, so the information that is provided can't be used against that person in civil or criminal proceedings unless that information that's provided is false or misleading. This power really ensures, or this provision really ensures the focus is on determining the facts of the incident to make sure that we can prevent that happening again and resulting in further loss of life rather than the subsequent prosecution. The Model Act and regulations will be supported by Codes of Practice, and these are very important documents. The Codes of Practice are admissible in court as evidence of whether a duty has been complied with. They'll also provide evidence of what is known about a particular hazard or risk and control measures, and can also be relied on determining what is reasonably practicable. Those codes of practice really set the benchmark, and you can choose to follow that code, or you can choose to follow another way which provides the same or better level of protection. So a good example in this respect is there is a general risk management code of practice. You can follow that code, but if you're a more sophisticated organisation or a larger organisation, you may choose to follow the international standard on managing risk, ISO 31000. If you would like further information, you can jump onto our website at www.worksafe.qld.gov.au, or you can call our info line on 1300 369 915.